employees back to work. We hope you and your families are all safe and well, and certainly in the employment team we're all well and being kept out of mischief with lots going on. So what are we going to talk about today? Sorry, I've just realised I can't move the slides because I've got my picture in the way. There we go. So we're going to talk about how to get your employees back to work, whether that is back to work off of furlough and looking at working from home potentially, or actually most of the focus on the webinar will most probably be actually getting your employees returning to the workplace. Obviously, the lockdown is currently easing in stages, and that's certainly the plan. The end of the furlough scheme is on the horizon. Well, certainly the end of the scheme as it in its current format has got a couple of months left to run, and we're still waiting to see what it will look like after August. And we're also we also have obviously got employers thinking about how to get how to get staff back to work. So the government guidance is pretty clear that for the moment, as of the time we're doing this webinar this morning, workers that can work from home must do so. And so what we're going to look at today is, you'll see in a minute, there's a slide with some useful links for you, useful information. We're going to talk about employees returning to the workplace. Well, I'm also going to look at employees who are unable or unwilling to return, and we're going to finish the webinar by looking at some practical issues that we think may arise through this topic. As the webinar is live, and for those of you that watched our webinar a couple of weeks ago, then please, if you have any questions, do type them into the Q&A, and Matthew and I will answer them at the end of the webinar. So this is a slide that I just mentioned. It's sources of guidance, which we think you'll find useful. So we've got the Acas guidance there, which I'm actually going to talk about in a second. And then we've obviously got the Govt.uk guidance on the coronavirus and the most recent kind of health and safety, the working safely during coronavirus advice. And I've just put at the bottom there a link to the ICO, and that's just to remind you of tips for those employees who are continuing to work from home and security issues. So they're just a few of the useful links that I thought may be helpful for you. So looking at employees returning to the workforce. Now, what I've done is I've split this into kind of three key issues to think about. The first is health and safety. Now, under health and safety, as I'm sure you're aware, employers have a statutory duty to ensure the safety of their employees as far as reasonably practicable. And there is also the common law health and safety obligation on employers to take reasonable care for their employees. And essentially, in a nutshell, the three key things to think about is assessing the risk. Then, once you've done that, set up a safe system of work, and then implement that safe system. This is a non-delegable duty. The employer actually needs to implement the system themselves. They can't delegate that to somebody else. So I will look at health and safety in more detail. Matthew is then going to look at the issue of changes to working arrangements. So, for example, with the guidance looking at staff working in in bubbles, or the need to stagger shifts or stagger hours, so you haven't got so many in the workplace at the same time, or perhaps to avoid rush hour commutes. The key question you're going to be having to ask yourselves, I would have thought, is it necessary to make changes to your terms and conditions, to the employment contracts? And so that's something that Matthew will be looking at. And finally, under this section, we're also going to, or Matthew is going to be looking at data protection. And one of the frequent questions we're getting asked is, can we check our employees for symptoms, for example, temperature checks, antibody tests, and that of course throws up a number of data protection issues which Matthew will cover. So, before I talk about health and safety, I just wanted to make you aware, if you haven't seen it already, that the Acas Coronavirus guidance was updated towards the end of last week, and it has a lot more information on there now. So before, when it talked about those employees, well, it talked about kind of sick pay and self-isolation and holiday and those kind of topics. But now there's a lot more detail on there. And so I put some of the key points on the slide there. Again, the advice on staying at home for employees has changed from except in specific situations to an instruction to stay at home wherever possible and to limit contact with other people. There is a new section on if the workplace is open. And there's information on employers' health and safety obligations, which of course I'll come to shortly. Employers are advised that they must encourage staff to work from home wherever possible. If working from home isn't possible, the guidance suggests that staff might be furloughed, that they may use paid holiday or unpaid leave, but obviously it's not just quite as simple as just asking employees to, say, for example, take unpaid leave. There's also on the guidance a new section on keeping in touch, which is quite useful actually because it's got various practical measures which can be taken to support employees' health and well-being, especially for those that are working from home. In line with the health and safety guidance, it advises employers to consult with staff about returning to work. And of course, I'll come to the health and safety guidance in a second. And there's also sections on ending and ending or extending furlough. Employers are advised that they should regularly review their furlough arrangements to decide when to bring furloughed staff back to work. And they advise that to end furlough, employees should be given notice in writing. But of course, you will have your own template, your own furlough letters and furlough arrangements you would have sent out to your employees. And no doubt the terms of the furloughing will specify how and how quickly and in what form you may ask your employees to return to work from furlough. The Acas guidance is very useful, but of course remember that it's not statutory legislation. It is just something that's important, but it is important to be aware of it. So moving now on to health and safety, which is obviously is always a huge topic, but particularly now. I've highlighted the statutory and common law duties, and, you need to ensure the safety of your staff. And on Tuesday this week, the government published it's on Govt.uk, and it's 5 steps to working safely. And what they say is that these are practical steps for businesses to take. It urges it urges employers to read all the guides relevant to their workplace, and you'll be aware, especially if you click on one of the links on the other slide with the useful resources, that we've got lots of health and safety information out now from the government about returning to the workplace, and there are specific guides for different working environments. For example, the guidance is slightly different from those working in a factory compared to those working in an office-based environment. So the 5 main steps, I'm just going to quickly run through them under this guidance that came out 2 days ago. Number 1, carry out a COVID-19 risk assessment before restarting work. And I will come to risk assessments in a bit more detail shortly. Number 2, develop cleaning, hand washing and hygiene procedures. So, examples that this guide gives, hand sanitizers, frequent cleaning of and disinfecting objects and surfaces that are touched frequently, those kind of things. The 3rd step they suggest is help people to work from home. So that will be looking at discussing home working arrangements, ensuring that they have the right equipment to be able to work from home. Number 4, maintain the 2 meters social distancing wherever possible. And it gives you some tips there, which is, put up signs to remind workers of social distancing, avoid sharing workstations, putting down tape or paint on the floor to mark areas to help people keep this 2 meter distance, arrange one-way traffic if possible, and stagger hours if possible. So that was number 4. And then number 5, where employees cannot be 2 meters apart, manage the transition risk. Consider whether the activity actually needs to continue for the business to operate. use of screens or barriers to separate people, back to back or side to side working as opposed to face to face working if you're kind of in an open plan environment, and again staggering arrival and departure times. So those are the five steps. It is a useful guide because actually, as opposed to all the other health and safety guidance that's out there, which is in different places, this is kind of a practical guide that's pretty much on 1 or 2 sides of A4, which is quite useful if you wanted a good summary of the things that you need to be thinking of. So the first step that's on there, and the first thing we will be recommending that you do, is to carry out a risk assessment. And those should deal with the 3 workplace scenarios. And in order of preference, it is working from home. Secondly, then return to work and maintain social distancing. And if you can't do either of those, then the last result, or the third category, be returning to work where social distancing can't be maintained. So the risk assessment is going to need to consider the mitigating steps that can be taken to reduce the risk of transmission to the lowest practicable level. You'll need to be taking into account the nature of your business, the size and type of your business, how it's organised, the resources, and of course the layout of your premises. And also you need to, in this risk assessment, look at your employees. For example, are there any vulnerable employees? Are there any extremely vulnerable employees? Your risk assessment, if you have fewer than 5 workers, then you don't need to make a written record of it. However, if you have more than 50 or 50 or more, then the guidance is clear that the results of the risk assessment should be published on your website and displayed in the workplace to show that you're following the guidance. Okay. And the other thing with the risk assessments is that the guidance is also clear that employers should be consulting with employees about how to manage the risks around COVID-19. So I discuss the risk assessments with them and make sure that the employers can see the risk assessments that you've carried out. So as I've said, the guidance is clear that if employees can still work from home, they should do so. They should continue to do so at this current stage of, what are we, 4 to 3 of the chart of the risk level set by the government. Returning to work, so then the second category, if you need employees to come back to work, then maintain the social distancing. The third category of returning to work where social distancing can't be maintained is expected at this stage that is going to be very limited. So it's for those roles which are kind of business critical roles that can't be performed remotely. So obviously, at the moment, we really need to be avoiding getting into that third category of returning to the workplace and no social distancing. So as I mentioned, the risk assessment does need to take into account protection of clinically vulnerable employees. And I'm going to look at that category a little bit later on, and some issues around them and whether they can return to the workplace. So in summary, assess the risk, consult with your staff, set up a safe system and implement it. And once that system's been set up, as I've said, we need to implement it and we need to continue to implement it. So this will be about instructing employees what they need to do, making sure that we're managing the situation. And if employees are not following the guidelines that you've set, then we'll be looking at potentially disciplinary action.
Vanessa,
yes.
Just before we move on, a couple of questions about risk assessments.
Yes.
So in terms of risk assessments, should these be on the website or is the intranet okay? My understanding is it is the website rather than the intranet, isn't it?
Yes, that's my understanding as well. Yeah.
And then we have another one, which is if you have more than 50 employees, but most are out in the field, you still need to do a risk assessment and place it on the website.
Yes, I would have thought is the answer to that.
I agree. I agree. I think it just might be an easier risk assessment to do, but I think it still needs to go on there.
Yeah.
So we are talking about external facing websites so that everyone
yes.
can see them, rather than something which is just for the employees.
Yeah. And the other thing I was probably mentioning risk assessments actually is when I mentioned that document that was released, or that webpage that was released by the government 2 days ago, that just says publish the risk assessment on the website. It doesn't say anything about there being a threshold of 50 employees or not. So I would urge you actually anyway, even if you have less than 50 employees, to consider publishing the risk assessment.
There's also a sign I think all employers have to put up, isn't there?
Yes, there is.
Which is in front of the guidance, I think.
Yeah, and certainly, and also at our, we've got a great insurance and team which can help with health and safety and can help with risk assessments. So if anybody needs some help with risk assessments, if they're struggling with them, then please do get in touch with us, and we can certainly help you with that, because I think for many, risk assessments in this way is going to be quite new. So moving on, it's you, Matthew. That's good. I get a break. Changes to working arrangements, if we can.
Changes to working arrangements. Okay, what I'm going to look at is just looking at what the kind of working arrangement changes we might want to make, how we go about making them, and then what some of the risks or practical consequences are of that. I think the first obvious thing to do is to look at what we mean by working arrangements. What kind of things are we going to be looking to change? Well, I think if we look back at the guidance, if we look at what is recommended in terms of workplaces, for some, it may be the fact that actually there's going to be a pretty wholesale shift, either on a permanent or semi-permanent basis, to working from home. So there's a change in work location. What else are we likely to see? Well, we know that the government is recommending staggered work times. And so again, we're likely to see that some employers are going to have to change times at which work begins. Some of the other things I've been hearing about are employers who are closing very large offices and moving to regional hubs. So there may be other changes of location on that kind of basis for employees, or actually just complete flexibility about location. So some changes about that. The other thing, obviously, we are likely to be seeing is changes to pay schemes, either extending pay reductions just because employers don't have the money to pay what they have been paying, or combining that with a reduction in the amount of work to be done. So some forms of short-term working. So first step, obviously, identify what kind of changes you're looking at making. So when we've identified those, what do we do? What kind of process do we follow? Well, the first thing to do is actually not to assume that you are making a contractual change. In many cases, you will be able, as an employer, to say, well, actually, we've got discretion to make those changes. If we decide that we're going to stagger start and finish times because we need to ensure that our lifts are not too bunged up between the hours of 9 and 9:30, so we're going to stagger the working day start time between 8 and 10, then in many cases, I think the employer would be able to argue actually they've got the flexibility to do that. There is no change to terms and conditions. Same might apply with a location change. You may be moving employees 5, 6, 7, 10 miles further, or in a different direction to those that they have been used to. That doesn't necessarily mean there's a contract change, because you do have that inherent discretion. And that certainly is the starting point to look and say, well, actually, can we make these changes without any change to the contract? If not, if we look at it and we think, well, actually, it seems a bit more of a radical change, we really do need to look at getting some form of agreement with the employee. Then where do we go? And the obvious route is persuasion, not to launch into any kind of big consultation exercise or anything else, particularly in these times, because I think all employees understand that coronavirus is driving significant change. Actually, to sit down with employees and say, society is changing. What we've been used to doing can't go on before, and we need to try to change things. is the way to go. To try and get that persuasion in place is certainly the way to go. And I think even if you've identified that you might have some difficulties with forcing change through, or getting it changed agreed, it's always worth just starting with trying to persuade the employees to agree to whatever you feel they need to agree to. If we can't get that persuasion, if we can't get that agreement by persuasion, then that's where we start to get into more hard choices. Are we looking at imposing that change upon employees? Often referred to politely as a unilateral variation of contract. Unilateral variation of contract, other way of saying that is a breach of contract. Are you as the employer prepared to breach the contract? And again, many employers will think, right, well, okay, I know that there is a contractual change to be made here. I've tried to persuade my employees to accept it, but for whatever reason, they're not prepared to accept it in a they're not prepared to agree to it. So should I just impose it? And again, where those changes are reasonably minor, so again, changes to hours, perhaps changes to a location which you do not think is particularly onerous to send an employee to, then that's where we may think, well, we will impose the change and we'll put up with some grumbling, but actually we do not expect any legal action or similar to result from that. The kinds of changes I wouldn't impose are, first of all, any change which is going to see the employee with a loss of money. And the reason I say that is because as soon as there is a reduction in the pay that the employee is receiving to what they are properly entitled to receive, then you're into unlawful deduction from wages territory. And they're actually very easy claims for employees to make. They can make them while they're still employed. They're a headache to deal with, but you just haven't really saved yourself anything. So I think anything to do with pay needs to be properly agreed. And again, anything very significant or anything where you think there are real concerns about the employees effectively voting with their feet, deciding that they are not going to put up with that change. Again, that's where I would be reluctant to advise that we just impose the change and move on. Which brings us to the last change, and this is the one where we tend to use where there are more significant changes, fundamental changes, or changes that are affecting an awful lot of staff, and that's to we call it dismissal and re-engagement. The way it works is that you will consult with the employees, you will offer them a new contract which contains the clauses in the contract you want, and you will give the employees an opportunity to accept those. However, what you will say to employees is that if you don't accept, and after proper consultation, then you will issue notice of termination of that contract. And at the same time as issuing notice of termination of that contract, you will offer them a new contract which contains the terms which are more acceptable to you as an employee, as the employer. The employee then has a choice. They can either work down their notice and at the end of the contract they can leave, or they can accept those new contractual changes. So there's a bit of a process there. There is a consultation exercise to be done, but ultimately what you are saying to the employee in shorthand is, if you don't accept this change, then I will dismiss you. That's a very crude way of putting it, but it's a very effective way of getting some quite significant changes to the contract. So again, there's a number of ways you can go about these things. The important thing, I think, is first of all to assess what you are proposing to do, how significant that is going to be perceived by the employee, whether you're likely to get agreement to it, and if not, then how much do you want that change, and what are you prepared to do to get it? There's a question I'm just seeing: are they entitled to claim redundancy compensation if the job has significantly changed? It's a good question. Certainly, it's something employees will argue that there is a redundancy situation and therefore there is an entitlement to pay. Most of the time, if you are just doing a dismissal of re-engagement, then no, because to be entitled to a redundancy payment, you've actually got to be able to show that the employee's job has has disappeared. The work of a particular kind no longer exists. And what we're really talking about here is not where you're taking away the job, but where you're changing aspects of the job to make it more effective, efficient in the environment in which we now live. And certainly if you dismiss for that reason, we're not talking about redundancy dismissal, we're not talking about redundancy pay, we're talking about some other substantial reason being the potentially fair reason for the dismissal, and then that does not trigger redundancy pay. So on the whole, no, redundancy compensation will not be due. Just another question: if we dismiss and re-engage, will we be open to constructive dismissal claims? Again, the answer is no. You won't be. This way of doing things, i.e., saying we're going to dismiss you unless you accept the change, is actually about getting them to agree. It might be an agreement which appears to be under duress, but it's about getting that agreement. You only end up with a constructive dismissal claim if you have effectively breached the employee's contract. And what dismissal and re-engagement is about is avoiding that breach of contract, and therefore there should not be any significant constructive dismissal risk. But I just remind you, there is a need to consult. So what happens? Where are the risks? Well, we've dealt with some of these already. Obviously, if you are imposing a change to contracts, then there is a risk of a breach of contract or an unlawful deduction claim. Now, I separate those out slightly, and as I said earlier, really my concern about imposing a change where it is going to lead to a reduction in money is because that's where you give employees a very obvious claim to make for an unlawful deduction from wages. Actually, breach of contract claims, even with regards to wages, are quite difficult to make through the employment tribunal system where the employee is employed. So the kind of claims we worry about with breach of contract, where you're imposing contract, might be the removal of another benefit which is significant to the employee. So it might be a case that you remove a contractual commission scheme, or you remove some other form of benefit, so life assurance or something like that. That's where you've got something which can be seen as quite a quantifiable loss, the cost of putting into place another insurance policy, and that's where you're more likely to get breach of contract claims. So there is a risk, and that should always be assessed when you're looking at whether you are going to impose a change or whether you are going to take some other route. We look at constructive dismissal claims, and as I just said, they're the claims where which the employee makes where they've effectively been forced to resign. Now, constructive dismissal claims comes about because you as the employer are alleged to have breached the contract, but the most valuable element of it is an unfair dismissal claim, i.e., you constructively dismissed me, you forced me to resign, and that was unfair, and that's what leads to the unfair dismissal claim. So again, we can see constructive dismissal claims coming when you have imposed a very significant change on employees. Now, again, and this is the cynical employment lawyer in me talking rather than the human being, what we tend to see at times like this, when there are not other jobs around, is that employees will actually put up with an awful lot before taking that decision to resign and claim a constructive dismissal, because effectively they are putting themselves out of work and taking the risk that will be compensated for at a later date via the tribunal, and that's a big step for employees to take, particularly when there are not an awful lot of jobs out there. So constructive dismissal claims themselves tend to be quite rare, and in many cases employees will be prepared to suck up quite a bit of bad treatment rather than take that step. Unfair dismissal claims can arise in terms of that dismissal and re-engagement process I was talking about. The reason for that is it just triggers normal unfair dismissal rules if the employee does not accept that new contract. As I said, it's some other substantial reason, potentially fair reason for dismissal. That means that the employer must show that they had a good sound business reason for the change that they were proposing to make. They must then show that they followed a fair procedure. And in essence, that procedure looks like, we need to make this change because of the business. We will informally ask employees whether they accept or are prepared to accept, we will engage them in a process of consultation, negotiation around that to see if we can make it more palatable. If they can't, then we will have a consultation meeting with them, which is against the background of them knowing that they can be served notice. If they still don't agree, we serve that notice, but at the same time we offer that new contract, and we allow that notice to expire before the offer of the contract expires. So we need to follow that sort of process if we're going to avoid an unfair dismissal finding. The other risk we have, and this is where we are dismissing and re-engaging or threatening to dismiss and re-engage, is that we trigger the collective consultation regulations. Now, I said a minute ago that if we're looking at dismissal and re-engaging, we are not making redundancies. We are not giving employees an entitlement to a redundancy payment. That's because redundancy pay is a matter of UK domestic law, and the definition is under UK domestic law. However, the collective redundancy obligations to inform and consult, where you have potentially more than 20, is a different definition of redundancy. It's much wider, and it effectively encompasses any no-fault dismissal. So if you are in a situation where you can say, right, we need to make this change to, say, 100 employees within our organization, and it's quite a significant change. And of that, we expect most will sign up, but we think that, first of all, if employees don't sign up, then we will issue them with notice. We will terminate their employment. And secondly, it is likely, given the nature of the change, that there could be more than 20 of those in that situation. Then we have triggered the obligation to collectively inform and consult. Okay, so we must build that into our process. It's important we do it because of the very significant compensation that can arise if we fail to effectively collectively inform and consult. So for dismissal and re-engagement, we can trigger these because of a very specific definition of redundancy that exists at European level. But that doesn't mean that we are giving employees an entitlement to a redundancy pay as well. Sorry, I know that's confusing. It's because we've got the same word with a different definition, depending upon the circumstances. But hopefully that's reasonably clear. So we need to look at what changes we're making, why we're making them. We need to look at the contract, see if we can make those changes under the contract. And then on the back of that, we need to ask ourselves, will the employees accept this? Will they not? And then we can start to put our strategy in place, looking at those three risks and how we mitigate them. And that's really all we do to effect changes to working arrangements. As simple as that. Moving on from one simple subject to another, data protection. This has become a very live issue in the context of COVID-19. Largely because, of course, COVID-19 is a health-based issue. The contagious nature of the virus means that in certain circumstances we will want to know and understand whether or not an employee has symptoms or is carrying the virus, and that also feeds into the health and safety aspects of a return to work. So what we are already seeing is inquiries coming through from clients asking about what kind of steps they can take to test for antibodies, to ask employees about whether they have symptoms, to ask employees about whether they've had COVID-19, etc. Information Commissioner has been very good, very proactive on this, and actually has come up with some, I think, pretty conclusive guidance, which should give us all some comfort. And what the sorry about that. And what the Information Commissioner is saying is that this is clearly a data protection issue, and it must be treated as a significant data protection issue. And for employers who do not, then they can expect to be sanctioned accordingly. However, having said that, there is no reason why data protection should stop employers from ensuring that they are properly able to protect their workforce. What the guidance from the ICO says is, well, first of all, you've got to remember that whenever you are processing data, you must have a lawful basis for that processing. And what they are saying is that there is a lawful basis for processing data when it relates to either checking for symptoms of COVID-19 or checking for antibodies of COVID-19. And that lawful basis is a legitimate interest. There is a legitimate interest for employers to ensure that COVID-19 is not, quotes, brought in, close quotes, to the workplace. So we can use that. If we're using that, however, we need to remember that we need to have a impact assessment, i.e. we have to assess that the measures we are taking benefit us more than they cause any kind of risk to the rights and freedoms of the individual data subject, the employees. So as well as our risk assessment, which the government now requires us to do when we're taking employees back to work, we need to have a legitimate interest impact assessment if we are looking at monitoring for symptoms of COVID-19 at all. We have to go further because, of course, symptoms of a health-related condition trigger the special category elements of GDPR. Health-related data is special category data, and we need an additional permission to be able to process that data. And again, Information Commission has been very helpful on this and has signposted us towards the permission that exists, which is under Article 92B of GDPR, which is that we are doing this in accordance with our employment obligations to maintain amongst other things, the health and safety of employees. So we have that lawful basis, we have that additional basis, and that's really important. Information Commissioner again reminds us, however, of the transparency obligation. Whenever we are processing data, and this will be a new form of processing personal data, we must ensure that we have a privacy notice. We must ensure that we have informed the employees about this. Reminder of confidentiality. You need to keep the health-related data to as fewer people as possible. For many organisations, that may be occupational health. For other smaller organisations, it may be an outsourced occupational health service, or it may be the HR team. Clearly, if it is going to be the HR team, then the tests need to be proportionate to the fact that the HR team are not medical practitioners. And again, that information must be kept very securely internally. And again, the last thing that the Information Commissioner advises us about is to have a retention schedule in place, i.e. we should not be keeping this data for longer than is necessary. What that means at the moment, I don't know. It may be, if we're very lucky and we have a vaccine by the end of the year or early next year and COVID-19 is eradicated, then that's the point at which we will no longer need that retention schedule. But we need to be thinking about it, we need to be recording it, we need to be making sure that all the paperwork is done if we are going to be in a position to be able to test this. But effectively what we are being told is, yes, you can go and monitor employees for symptoms of COVID-19, but you've got to do it properly. And back to you, Vanessa.
Thank you. Before I move on to looking at employees who are unable to return, I noticed that there was a few questions still on risk assessments. I think I'll just tackle those now, if that's okay, Matthew.
Of course.
So one of the questions was, yes, just asking us the sign that you mentioned, Matthew, just a question on that. So I think what Matthew's referring to is that there is a notice that employers are required to display in their workforce, which basically is just a notice that confirms that you're following the government guidance. And the notice is called Staying COVID-19 Secure in 2020. And where you find it's on the Govt.uk website. So it's the website of Govt.uk, which if you put in Google or any other internet browser, working safely during coronavirus, Govt.uk, and I'm sure then that will take you to where you can find that notice we referred to. Another question we had was, can we publish a summary of the findings and steps we will manage to reduce the risks rather than the full risk assessment? Now, I've just had another sneaky look at the guidance while Matthew was talking, and the guidance talks about publishing the results of the risk assessment. So I think if your summary is comprehensive enough, then I think, yes, you probably could just publish the findings and the steps rather than the full risk assessment, because, and I've looked on Govt.uk and also the Health and Safety Executive website, and it does all talk about publishing the results of the risk assessment. And the final question we had at the moment on risk assessment is there a template for this? Yes, there is. There are some templates. If you look again on the Health and Safety Executive website, hse.gov.uk, there is a template risk assessment, and there are also some examples of how to complete the risk assessment. And the examples are based on different kind of workplace environments. So do have a look at that. That may well help you. But of course, with the examples that are given, don't just cut and paste them. You need to kind of actually properly, as I'm sure you would, consider all the risks and how you'll manage them in the proper way, directly relevant to your workplace. But hopefully that will. But hopefully that resource for the templates will assist.
And sorry, Vanessa, there's just one question on privacy notices.
Yeah.
Do we need a new privacy notice for COVID-19 sickness on top of normal sickness recording privacy notices? It will depend upon whether or not you are recording for symptoms of COVID-19 or undertaking any testing. If you're just recording normal sickness absence, then probably not. If, however, you are doing anything new because of COVID-19, either in the way you are recording or in the fact that you are doing some testing, then yes, you will need a new privacy notice to cover that.
Great. Thank you. Right, so next topic, employees who are unable to return. And I split those into 3 categories there. So the first is a protection of clinically vulnerable and clinically extremely vulnerable individuals. Just by way of brief introduction, the distinction between clinically vulnerable and clinically extremely vulnerable. So the clinically extremely vulnerable, look at the government guidance for this, because they do regularly update those employees who are clinically extremely vulnerable. They include those with certain cancers, those with severe respiratory conditions, and those that may have, I think, organ transplant recipients. But yes, it is regularly updated. So that is one group, clinically extremely vulnerable. We then have another group, which are the clinically vulnerable, and those are individuals that are aged 70 and over, regardless of whether they have any underlying health conditions or not. Women who are pregnant, and individuals under 70 with an underlying health condition. And again, there's a list of what these are, but those include individuals with mild to moderate respiratory disease, chronic heart, kidney or liver disease, diabetes, and those with an weakened immune system. But it is important, as you'll see as we go through, just that we know if employees fall into a group, which group they fall into. So for the clinically extremely vulnerable individuals, they remain strongly advised not to work outside of the home. And this is also the case that really with the clinically extremely vulnerable, an employee who falls within this group is also likely, obviously not guaranteed, but likely to be disabled under the Equality Act. So our advice here is that you do not require these employees to return to the workplace if you're opening up under the current guidance we have at the moment. If you do require them to return, then there are a number of issues you may be facing, including potential direct disability discrimination or discrimination arising as a consequence of the disability, because of course they've been told to shield, and that shielding requirement is a consequence of disability. There would also be potentially, well, there would be really a breach of the health and safety obligations because they've been told not to return to the workforce. So that group needs to stay at home, and I'm going to come to pay in a minute. Obviously, we do have a potential crunch point looming because, of course, a number of those individuals will be on the furlough scheme, and we know that furlough in its current form is due to end at the end of July. And And so if extremely vulnerable individuals are still going to be advised to shield and therefore unable to come into work and they can't work from home, then, whilst we have that option at the moment to place them on furlough, that potentially would end, or it would actually cost the business more once we know the contribution the businesses need to make from August onwards. I understand that there is currently some lobbying for furlough to be extended just in relation to this clinically extremely vulnerable group. But of course, we don't know the outcome of that. And I think the government, it seems, is quite key to keep things kind of across the board as opposed to kind of signalling out certain groups. But we will see. So for those that are in the clinically vulnerable group, the health and safety government guidance is that that group should be taking, so the government guidance for that group should be that they take extra care in observing social distancing. And the health and safety guidance for us states that we should be helping these employees to work from home in their current role, and if they can't work from home in their current role, look at whether they can work from home in an alternative role. If clinically vulnerable individuals can't work from home in their role or a different role, then they should be offered the option of the safest available on-site role, which will enable them to social distance from other employees. And the health and safety guidance says that if you're unable to guarantee the social distancing of other staff, then you'll need to carefully assess whether this involves an acceptable level of risk to have them back into the workplace.
Vanessa, there's just a question that's come through on that theme. I think it just takes it one step further, so it's probably worth asking now. So if someone in the clinically extremely vulnerable category wants to return on a social distancing basis, should we allow them to? So I think we've just dealt with the situation of the employer not being able to do anything other than allow them to return because they can't work. But if it's just a personal preference of the clinically extremely vulnerable person, then I think the answer is no, they shouldn't be.
Yes, it is. It is definitely for those that are in the extremely vulnerable category. Then you shouldn't allow them to return to work at the moment, whilst the current government guidance is in place. I think if you do, there are, potentially, consequences in terms of health and safety and your obligations. And remember where I said that you can't delegate your obligations in relation to health and safety. So you can't, i.e. delegate the decision back to the employee. It's the employer's responsibility. So no, you shouldn't allow them to return to work. There's a few other questions that are coming in, aren't there, as well?
There are. Might be worth dealing with these now. So other questions. Are we able to ask individuals to prove they're clinically vulnerable, especially if we are not aware of any condition?
So I guess are we thinking that kind of issue may arise if somebody says, I don't want to return to the workplace because I'm clinically vulnerable? We're thinking, well, actually, we have no evidence of that. I think yes, and I'm going to be kind of coming onto this in a little while. If somebody kind of says, I don't want to return because of, we'll have to ask questions. And yes, I think we can validly ask for a doctor's note, as you would under any other sort of circumstances if somebody needs to certify their absence. Matthew, would there be any particular data protection issues we would need to touch on that?
No more than I think for any other medical record that we're keeping. We should be covered for that. That anyway. And I suppose just there's a couple more questions. Another variation on the theme on this: if an employee over 70 can't work from home and wants to return to work, can they?
Yes, they can, but again, just look at what just think about what I was saying in terms of social distancing. So if they want to return to work, can we put them in a role, or can they pull their current role at a place where it's safe to do so and there's social distancing? If you feel you can't, for whatever reason, given the nature of the role, effectively socially distance, and when you carry out your risk assessment, you think it's not safe for them to return, then no, they shouldn't return.
Yeah, and we should be looking at that obviously from a symptoms and a health perspective rather than an age perspective, shouldn't we? Otherwise we start to get into some discrimination issues.
Yes, we do. Yes.
Okay, right, I'll let you carry on. Sorry, I just thought that was a useful diversion.
Right, do we want to answer the other questions, or are we?
I'm I just wondered if you were going on to talk about the other questions anyway. But
let me carry on, and then and Matthew, I know you'll kindly make a note if I haven't answered any of the questions that are on there. Thank you. So we talked about extremely vulnerable and vulnerable, and what I was just going to say is that just obviously, if you do require an employee to work, if they fall into the vulnerable categories, then do carefully consider the situation. So if the employers are unable to work remotely, what do we do about pay? So unless they or a member of their household are experiencing symptoms of COVID-19, then clinically vulnerable employees are not entitled to SSP if they're unable to work remotely. So the alternative would be to continue to pay them on full pay or place them on furlough if appropriate. However, employees who are clinically extremely vulnerable and who've been notified to follow shielding measures are deemed to be incapable of work for the purposes of SSP. And so if they're unable to work from home, yes, they're entitled to SSP. There are other pay options that you may be able to consider is if you have a PHI scheme in place, would potentially employees be covered if they're unable to come to work and they're not able to work from home? That's something else to have a look at. I'm just going to quickly talk about employees who need to self-isolate, then I think I'll pause there, check whether there's any other questions before talking about childcare commitments. So employees who need to self-isolate, so these are basically employees who have symptoms, or if a member of their household have symptoms, then they should not be coming into work. If they can work from home, then they should be working from home. But obviously if they're well enough to do so. And where an individual self-isolates in response to a direction by a medical professional or because of government guidance, and of course we've got lots of government guidance about self-isolating at the moment, then they are deemed incapable, and so they are entitled to SSP, or of course any contractual sick pay that you may have. Where do we think we got to on the questions, Matthew?
All right, sorry. Yes, one useful point. Thank you for this. Just to remember that most extremely vulnerable or people in extremely vulnerable groups did receive a letter, and that can be used as proof, which is a good point, and maybe a shortcut to that. Interesting question. Do we have to wait for an extremely vulnerable person to approach us, or do we approach them if they have a health issue? I suppose that's going to slightly depend upon whether or not it's an obvious health issue to us, isn't it?
Yeah, it is.
But I suppose I think what we've got to remember is we're the ones who have the obligation as the employer to protect health and safety, and we shouldn't necessarily assume that employees are going to voluntarily raise issues.
No, and I think that's probably where also it comes down to having the risk assessment and then consulting and discussing the risk assessment and the risks with the employees, because that's then their opportunity to say, I fall into this group or I fall into that group.
Yeah, absolutely. And then another one, and this probably goes also with the childcare commitments, so probably a useful segue into that. So if the employee doesn't fall into these groups, but someone in the household does, can the employee return? So if you are living with someone who has to shield, I suppose, you've got an issue there.
Yeah. Yeah, I think that probably falls into the kind of the childcare category a little bit, doesn't it? Yeah. Just in case of, well, actually, in terms of our health and safety and our obligations, we're kind of looking at our employees.
Yes.
But actually, given the current pandemic, we're looking at, reasonableness and fairness of steps that employers are taking. And if there are alternatives that we can offer, then we should be offering them at this stage.
Yeah, I think
that.
Yeah.
Okay. So employees with childcare commitments. So we have a staggered return to primary school from the 1st of June. But I can speak from direct personal experience, having discussed this with Matthew this morning prior to the webinar, that's looking very uncertain. And I think once they return, even if they do return before, it would say they return in July, we're then suddenly on summer holiday season. So it's very likely that if employees have childcare commitments at the moment, that they're likely to continue, because of course, nurseries may well remain closed, and of course, perhaps their grandparents were helping with the caring responsibilities, but of course, for many parents, that's not so much an option now because, of course, the grandparents are falling into vulnerable groups. So Boris seems to be thinking, when asked questions about what employees or employers should do, is he says that he's sure employers will be sympathetic to their staff who have childcare commitments. And I think obviously the starting point is going to be, can your staff work from home if they have childcare commitments? Whilst in normal circumstances, it wouldn't be appropriate for an employee to work from home whilst also providing childcare. Many employers are indeed taking, a pragmatic approach to this, and a blanket ban on working from home may actually preclude a large proportion of workforce from performing any duties, which would affect your business, and also a potential blanket ban on working from home may also constitute potentially indirect sex discrimination, because of course women are seen to have had the lion's share of childcare responsibilities. So really what's happening is employers are taking a more relaxed and flexible approach to home working. We do have I keep mentioning the furlough scheme today. It's not about furlough today, but the furlough scheme is due to be made more flexible from August, and it looks like it's going to allow part furlough, part-time working. So that may be an option for those with childcare responsibilities come autumn. And the other thing you could do is perhaps agree to a variation in hours with the employee, so perhaps they can share the childcare responsibilities with their partner. But of course, some employees may be a bit reluctant to do this if, of course, their hours are being cut and there's a corresponding pay cut. But it's all, I think, at the moment, it's just being seen to be reasonable, having the discussions with the employee. And of course, a lot of it will depend on their particular role and whether you need them in the office or not. In terms of an actual right to stay at home and look after children, just remember we do have the right to take time off to care for a dependent. But time off in these circumstances is unpaid, unless there's a contractual right to pay for time off to look after dependents. And so I think, given the duration of the lack of childcare for parents, this is unlikely to be an appealing option for employees. But I just mention it just so that we do not forget about the time off to care for a dependent. I was then going to move on to my last section this morning, which is that million-dollar question of what do we do if an employee refuses to return to the workplace because they're worried about catching the coronavirus. And I think I've already had this question a few times over the past couple of weeks. So let's first of all just look at the law on this. We have, under the Employment Rights Act, we have two very relevant provisions, which is Section 44 and Section 100. And these are kind of rarely been looked at up until now, but now are suddenly very, very relevant with the COVID-19 pandemic. So Section 100 protects employees from dismissal on the grounds of absence from work if that absence was due to a reasonable belief that attending work would put them in a serious and imminent danger, and they could not reasonably have expected to avert that danger. There's no qualifying service needed to bring a claim in respect of an unfair dismissal if they were dismissed on those grounds. It is also an automatic unfair dismissal. Section 44 protects employees from being subjected to a detriment because of an employee's absence if that absence was due to a reasonable belief that attending work would put them in serious and imminent danger. So you can see that, employees potentially may raise the argument that they're worried about returning because they're worried about catching coronavirus, and that could put them in serious and imminent danger. Danger has been interpreted broadly in case law, so it is certainly feasible that it could include the risk of contracting COVID-19 from an infected colleague or client. But it does need to be a reasonable belief of serious and imminent danger. That is a subjective test. It's based on the employee's perception. So just because you might have a handful of employees who are willing to return to the workplace, and then you have one that says no, serious and imminent danger, doesn't necessarily mean that they don't have a reasonable belief in that danger. Remember also that employers have an implied duty to take reasonable care of the health and safety of their employees, and are obliged to provide a suitable working environment. And obviously we've got the implied duty of trust and confidence, which may be breached if we treat an employee detrimentally if they raise health and safety concerns. So we're looking at potential constructive unfair dismissal, and also just think about the potential for whistleblowing. So that's the law, and on the face of it, there's a lot of protection really for employees in this situation. So what are we actually going to do? Let's get practical. If an employee refuses to return, what are the options? So if the employee can work from home, this may resolve the issue. If they can't work from home, then look at the current, and I say current because of course it does move, public health advice, and talk to the employee about their specific reason as to why they're concerned about attending work. Also consider whether it would be discriminatory to refuse home working, or to take disciplinary action or withhold pay. Is there a potential disability, for example? If there isn't a discrimination angle and you feel comfortable that on the public health advice as it stands at the moment, or at that time, the employee could reasonably be asked to attend work, then it is possible to investigate the employee for potential misconduct in terms of their refusal to follow a reasonable instruction to return to the workplace. And of course, their refusal would also constitute unauthorised absence. Of course, if the absence is unauthorised, the employee is then therefore unlikely to be entitled to pay. However, we just say, I think, just be cautious, because of course the context of a refusal to attend work does need to be carefully considered before going down the disciplinary route. If the dismissal or disciplinary action relates to the raising of a health and safety concern, or is because of the employee's belief of there being a serious or imminent danger, then of course we're looking at potential unlawful detriment or automatic unfair dismissal claims. So I think, in conclusion, I would say carefully consider an employee's justification for failing to attend work before taking any action. And again, this is where this is why we talk about, when we're looking at health and safety and we're looking at risk assessments, to communicate with employees about them, to plan and to discuss safety measures with them, and to seek to understand any concerns that they may have and try to act on them. Other options, if an employee does refuse to attend work, well, of course, we've still got furlough at the moment. Maybe an option you would consider. And also you could consider health and safety suspension, but that would need to be on full pay. And obviously that is expensive and potentially not sustainable for your business, depending on its size and its resources. So it's a tricky area. And I think in conclusion, I would just say it's one that you have to tread quite carefully, or very carefully.
Okay, thanks, Vanessa. Yeah, I agree. It's just one we're waiting to see. The legislation isn't brilliantly set up to deal with it.
No, it's not.
It's certainly going to be tested over the next two or so years. Yeah. Just a couple of questions we can deal with very briefly, because I'm conscious of the time. So if you've got an employee who's not isolating and not part of a vulnerable group and has been working from home easily, but they wish to return to the office to work, should we let them? I think the answer to that is probably no, isn't it? Because I think if you take the guidance, what the guidance says is, if you can work from home, work from home. Yeah. The only two times when you shouldn't be working from home is if you can't work from home, or if you're, because of the nature of your job, or if your home circumstances are such that you can't work from home. So I think the answer to that is the employee should be remaining from home. Second question: taking time off to look after dependents is unpaid, but do they accrue holiday? And I think the answer to that is yes. What is becoming clearer and clearer is that, pretty much in every situation, regardless of what's happening with the employee, they accrue holiday. So I think you've always got to rely upon that holiday accrual happening. We were just going to deal, I think, with just a few final practical issues, which I'll whiz through because of the time, but then we can leave some questions. Don't waste furlough was a practical issue I was going to make. We've got some certainty until the end of July, and then we've got, well, at the end of May we should know what it's going to look like from the end of July to the end of October, and beyond the end of October we're not going to have furlough. The point I think I'm making there is that we effectively, I think, are expected to be planning for the workplaces opening again from the end of July, during the next 2 months. So doing all the health and safety stuff, etc. Now, rather than waiting too long. So I just wanted to make that point. Another issue which Vanessa, you and I have been dealing with an awful lot is how holiday works during this period, during furlough, etc. It is possible for employees to take holiday during furlough, and many employers are certainly requiring that. I think the top up to 100% has to be made though during that period. The other thing I think we're going to see is employers changing holiday policies. There may be further lockdowns where we will not benefit from the furlough scheme. Employees are also storing up huge amounts of holiday at the moment, and I think what I'm seeing, what I'm encouraging is employers to look at a more holistic holiday policy and getting that in place now. Getting employees used to the idea that you are going to be directing when they are taking holiday in a much more assertive way than I think many employees have been used to, and also refusing holiday requests. And in that vein, using the carry forward provisions. We know the working time regulations have been relaxed, and we can use the fact that holiday can be carried over for the next 2 holiday years, I think, to smooth over any particular holiday issues that we might have at the moment. So I would certainly be looking at what you will do with holiday and putting in place a new holiday policy, which just gets employees used to the fact that you're going to require a bit more control over their holiday. Some last points, particularly lessons from elsewhere. What are we seeing from those countries in the Far East and also elsewhere in Europe who are emerging from lockdown a bit earlier than we are? Well, first message is be prepared for further lockdowns. The most health authorities are getting everyone used to the idea that there may be further outbreaks of coronavirus, and that will lead to further lockdowns. So don't assume that we are just going to go back to work and stay back to work. The other thing, the rise of white-collar health and safety claims. As home working becomes more permanent, I think we have to make sure that our risk assessments are properly done with regards to home working. And also looking at the fact that that CV-19 in the workplace is a real health and safety issue, which is where the health assessments, risk assessments have gone. It's quite interesting. I was speaking to a Spanish lawyer who was saying about how the authorities in Spain actually have the ability to go in and inspect someone's workstation at home. So hopefully that won't come here, but clearly it's being seen as a sort of regulatory risk around the world. Don't neglect employees' mental health. As I said, these are early surveys, and again, the people I've been speaking to about this say they believe this is an underrepresentation, but over 50% of the population are experiencing or have experienced regular symptoms of stress as a result of the fact that we do not cope with change well, and we have had to go through some very radical change. So we need to pick up on that and deal with that and seen as a real issue. And I think that goes back to how we cope, in particular with those employees who have concerns about returning to work, even if we regard those concerns as irrational or unfair, given what we have all done to prepare the workplace. And finally, Vanessa's touched on this in terms of carer-related claims. And again, what we're seeing in other jurisdictions is assertion of discrimination rights, disability discrimination for those who have a particular vulnerability to COVID-19, indirect sex discrimination and other carer-related rights. And the one I didn't put down there but we referred to again earlier, is age discrimination. It is likely to be something which is asserted, I think, in many cases. So we're just starting to get to grips, I think, with the numerous practical issues that we're going to be facing for some time to come. And I think it's important we all keep up to date and just aware of where these issues are going. And we'll certainly be doing some more seminars, webinars on this as it develops. So I think that's where we wanted to stop. We've dealt with a lot of questions, but we've got a few more.
Yeah.
So we're okay staying around for a wee time to answer them.
Yeah. So I think I'll deal with a couple that I've noticed. So so we need to terminate an employee on furlough. Can we claim the 80% notice pay via the job retention scheme? Yes, we can, as long as they remain an employee and remain on furlough during the notice period, i.e. don't pay in lieu of notice, because if you do pay in lieu of notice, then you won't be able to claim it back. Another question, if lockdown eases and people can travel abroad but then need to self-isolate and return, would this be unpaid leave? An interesting question. I think, thinking it through in my head, that would then fall back into the self-isolating criteria category, sorry. So that would be looking at SSP. Do you agree, Matthew?
Yeah, I do. I think I think potentially SSP, unless the SSP regulations don't apply for whatever reason, and I think it would depend upon what the quarantine rules look like in that case. It goes back to what I say about holiday policies. I think we should be flagging this to employees, which is that if you take a decision to go abroad, and as a result of that you cannot return to work, then that either is taken as part of your leave entitlement or unpaid. But I'd be flagging it up.
Yeah, I agree. If we're in it jumped around. Yeah, if we're in consultation with employees on furlough being paid at 80%, do we have to pay 100% during consultation, like we would with notice? No. It's clear under the furlough scheme that you can consult with employees. I'm guessing this question is geared at potential redundancies. You can consult without breaking furlough, and during that consultation period, the normal furlough arrangements would apply, so you can continue to pay at 80%.
Yeah. So, question about risk assessments. So up until now, we've been using our internal channels to remind home workers to complete risk assessments. Do you think we should be sending an email asking staff to complete and return a workplace assessment at home? I think potentially yes. I say potentially because I think, first of all, you've got to ask whether or not employees are going to be returning to work anytime soon. So if you have employees who are going to be back in the workplace, or it's reasonable to think they'll be back in the workplace, say within 2 or 3 weeks, then I'd probably continue. If, however, you are going to have employees who are going to be working from home for a significant period, then I think you need to do as much of a workplace assessment as possible. And the way in which I would do it is an initial questionnaire to make sure that they have got equipment and all the necessary equipment. Secondly, to ask them if they experience any particular issues as a result of home working. If there are any alarm bells as a result of the answers to that, then I think you need to be a bit more assertive, and you need to be saying, right, initially on the telephone, we just want to talk to you about your home working, and try as best you can to help them through, I think, a more detailed risk assessment and a more robust risk assessment. And in particular, looking at what equipment you may need to get them to assist them with home working. Yeah.
Sorry, I've lost where we were because the questions are flooding in.
Yeah. If you have any employee not attending work due to a family member shielding, and the shielding member of the family are out and about, i.e. not shielding, can we request the employee return to work, or is this a risk? I think that's a very interesting one. I think what we are expected to do is take employees when they say that they have an issue at face value until that's no longer possible. I think I would be looking at this as a disciplinary issue. Yeah. First and foremost, which is we effectively enabled you not to work on the basis that you are complying with shielding obligations. The fact that you are not complying with shielding obligations mean that the arrangements we had with you are not valid, and that's a disciplinary. Clearly, I think we can't get them into work, but I would look at it as pure disciplinary, I think.
Yeah, I agree.
If employee takes holiday whilst on furlough, can we claim 80% of pay through CJRS? So we only have to pay 20% top up ourselves? Yes.
Yes.
You can, and you just need to look at making sure you've calculated their pay properly for holiday related purposes. Can consultation be done via post and email rather than face-to-face whilst on furlough? That's a good one. I think only if you have discounted all other options, and by that I mean web conferencing
or telephone,
and telephone.
simple telephone. Yeah.
Yeah. So I think purely doing it via correspondence is at the more risky end of consultation processes. Better off offering it face to face or on telephone. If the employee refuses or it's just not practicable, then yeah, that's how you're going to have to do it. But I put it as a last resort.
Yeah. And then to avoid employees abusing the paid time off with COVID symptoms, are we allowed to say that only one period of potentially COVID-related absence will be paid? Again, I think that's quite difficult just to have a blanket. Only one lot will be paid because, of course, people may need to self-isolate because of being a member of their household catching COVID, and then perhaps a couple of months later, then they have symptoms. But I think if you have employees who, like with any kind of sickness absence monitoring, who are, repeatedly every month needing a week or 2 weeks to self-isolate, then I think you could potentially look at disciplinary if you want to question the validity of it. But I think a blanket only once would be very, very difficult and risky.
I think also what we need to do is just through, and it goes back to perhaps looking at contract changes. We may see employers sort of separating out their SSP obligations and what they pay under SSP from what they're prepared to pay as part of their occupational sick pay scheme, and saying that actually there might be different rules in place for employees who are off with a COVID-related absence, if they are in particular if they are asymptomatic. I can see, as well as looking at holiday policies, looking at sick pay policy might be a good thing to do.
Great.
Right, I think that's all the questions.
We do, and we have some lovely thank yous. So we're glad you found it useful. So sorry, we were aiming to keep within an hour, but we like receiving all the questions though.
Feels like you're actually talking to people, doesn't it? On one of these.
It does. It really does. Rather than just the screen. So yes, and I think we will be doing another webinar hopefully in a couple of weeks, won't we, Matthew? We will. Yeah, we'll get invitations. And if there are any suggestions for topics, please send them in. Yes, do absolutely. Be very gratefully received any topics. So thank you very much for listening to us. I hope you have a fantastic bank holiday weekend. The sun's meant to be shining. So yes, thank you very much. Thanks all. Bye-bye. Bye.